in. I heard it was particularly difficult parking out there today. Welcome. I'm Jenny Mobbs. I'm the CEO of CODA ACT. For those who have not been, we run these sessions every month, and I must acknowledge that we meet on the land of Noongar people and pay my respects to their elders past, present and emerging. Each month a session like this is conducted. This is one of the smaller ones, actually. We've been packed to the rafters for a couple of them. Just a bit of housekeeping. The bathrooms are out the back door there and to the left. The coldest place in the building they are today, but so you'll be nice and quick when you go there. But today we are reflecting a little bit on World Elder Abuse Day, which was on the weekend. We have World Elder Abuse Awareness Day celebrated each year globally and provides an opportunity for communities to stand together against the abuse and mistreatment and neglect of older people. When I first, a bit of a confession, when I first started here, which is a little while ago now, I'd been here a week and one of the policy people said, "And you'll be presenting at the World Elder Abuse Day session in the hall." And I must say that my background's actually early childhood, believe it or not. And so I said, whatever is elder abuse? Very naive of me. So I certainly had to skill up and find out a bit about it. And we do actually see it comes in many forms. It can be financial, emotional, psychological, physical, sexual or social. And it can occur once or many times and varies according to the severity from subtle through to extreme. Most often elder abuse is carried out by someone known to the older person. And most recently we found that 14.8% of those over 65 have experienced at least one recognised form of elder abuse. So today we actually have people who we go to for support with any situation where we might suspect there has been some abuse. These organisations, Karen, Adam and Fiona are here today from the Human Rights Commission, from Legal Aid ACT and from Services Australia. Thank you so much for being here. It's really good to have you here as support, and we know how often we ring you and chat to you about different issues that come in our front door and the other way around as well. So really, I thank you very much for being here. You'll have an opportunity at the end to ask questions, and I'm sure that Karen, Adam and Fiona will be around the place afterwards for individual questions if you don't want to ask in front of a group. Totally understand that. But thank you for being here today, and I'm going to hand over to Adam right now.
Okay. Thanks, Jenny. My name's Adam. I'm part of the Opals service at Legal Aid, which stands for the Older Persons ACT Legal Service. We're going to be talking a bit today about planning for the future and a little bit about elder abuse as well. Yes. All right. So the Older Persons Legal Service ACT is a specialist service within Legal Aid. Legal Aid's been around quite a while, and there's some of the issues that we see and deal with, elder abuse, power of attorney, guardianship, financial arrangements and other matters. And in fact, even if you were to have a motor vehicle accident or something like that, the Opals service would help as well. So we're going to be outlining some of the issues today. And Opals is confidential. It's flexible in the sense that we can potentially come to someone's home if they are unable to come to us, and we can give advice on the phone as well. And there's no cost to our service. We're going to be talking about planning ahead today. Some of the things we'll be looking at are wills, general powers of attorney, enduring powers of attorney, advanced care plans or statement of choices, and other issues and things as well. Okay, so firstly, what is a will? I think most people would know what a will is. It's a document that records your wishes that will be followed through after you die. So all your property, as you would know, will form part of your estate, and the will outlines who is going to get your assets and so forth. So first thing you would want to do is choose an executor. They're the person who manages your estate. And you'd also want somebody who you can trust to be your executor. And you'd have to also decide who you're going to give your assets to. It's important for you to think carefully about a will. And if you die without having a valid will, then that's called dying intestate, and that will mean that your assets will have to be distributed according to law. Okay, I'll talk a little bit about that later. So, ways to make a will. Of course, you can see a private lawyer and contact the Law Society on that number. They can refer you to a specialist law firm who does wills and estates. They can help you in a number of respects, especially complex wills. And if you've had complex family arrangements, for example, you may have separated, divorced, or remarried. There might be children from different marriages. So that would be a complex will, and it's a good idea to have a private lawyer for that. You'd be looking at maybe from $600 to $1,000 for a will, but it could be even greater if there are multiple properties, for example, in different states, for example. So that you'd probably require a private lawyer for that. There's also the public trustee and guardian, which can provide a free will, one every 2 years. And the criteria is you're 60 years or older, a concession card holder, you're in financial hardship, or an Aboriginal or Torres Strait Islander. So it used to be the case you had to appoint a public trustee as an executor in order to get a free will, but that's no longer the case. There's also community wills days that is offered by the Salvation Army. I did look up that this morning to see whether there's any in the ACT, and unfortunately there isn't. They've got them available in other states at the moment, but none as far as I could see in the ACT, but they do offer them from time to time. There's also online do-it-yourself will kits. We wouldn't necessarily recommend those. They do have issues. I mean, they may be okay for a very simple estate, simple will. You just got a house, nothing else, and you want to gift your house to 2 kids or something like that. That's it might be okay for that. But there have been issues with online will kits that they don't, for example, explain different aspects of drafting a will, and also they don't deal with tax or superannuation sufficiently. So it's always good to get advice, because it's a very important document. You're only going to do it once, or every few years. We would recommend, if you do have a will, to update it every few years, maybe 5 years at the maximum, because things can change. Okay, and also I might mention just briefly about the wills. If you fail to adequately provide for your kids or adult children, potentially there can be challenge under the will, but we can wait for questions after this presentation for that. Okay, general power of attorney is a financial document that you can draft now, that can take effect now, and it has effect while you have legal capacity. They can be in place for a specific time or indefinitely. Some of the things that often people will do a power of attorney is if, for example, you go overseas for an extended period of time, say 2, 3 or 4 months or even less, and you want people to take care of your bills at home, pay your rates, pay electricity, that kind of thing, or take care of your house, deal with your bank and stuff like that. So power of attorney for a particular period of time can be useful there. Also, you can have a power of attorney, for example, some older people don't like dealing with the internet or sent a link on the internet or MyGov or something, and you might have a power of attorney just very specifically for that purpose for some specific person to help you there. The power of attorney, the general power of attorney ceases to be effective when you lose capacity, and it ceases to be effective when you die. So it didn't, will kick in when you die. Enduring power of attorney, a little bit different. It becomes effective when you lose capacity. Generally speaking, there are some, you can have it become immediately effective in relation to financial matters, but generally speaking, they're made a long time with something that may happen a long time into the future. So if you made one now, it might take effect in 10 years or even 15 years time. And it's a document that enables somebody to take care of your matters when you lose capacity and you can't make decisions for yourself. And if you don't have enduring power of attorney and you lose capacity, then someone with some interest, a family member or a friend, may have to apply for guardianship on your behalf. So it's important. And then, of course, you don't have a decision who your attorney is going to be there. So you might want to consider enduring power of attorney sometime in the future. Decision-making capacity, that's sometimes it's very difficult to determine if somebody has this decision-making capacity or not, but it's a legal term that refers to your ability to make your own decisions, and you may lose capacity due to an accident or illness or effects of aging, but you have to understand the information relevant to the decision to give effect to your decision. So having capacity means understanding everything, being able to make a decision with that in knowing those things. You have to retain information. That is, you've got to have reasonably good memory, because if you forget, somebody tells you something and you forget something 5 minutes later, that's a concern. You have to be able to weigh up information and understand things. If I'm talking to a client, for example, and they're referring to somebody, they want to gift something to a child that's already died, and that's an issue if they don't know that they've died or can't remember. So it's important as lawyers we understand that, but it's also an important for you to understand as well. Who to appoint as an attorney? You can only appoint somebody who's 18 or over and has capacity themselves. They can be a family member, friends, lawyer, licensed trustee or public trustee. They should not be bankrupt or insolvent. Now, you should choose an attorney carefully, someone who you do trust, and also that you consider has the ability to be able to do things for you and understands how you would want decisions to be made. A power of attorney can be revoked at any time. So while you have capacity, whether it's an ordinary power of attorney or an enduring power of attorney, that can be revoked at any time. In the ACT, there's no specific form for that. A simple one-page letter saying hereby revoke the power of attorney made on this date is sufficient, signed by you. And it doesn't need to be witnessed, but I would suggest people should get witnessed. Okay, the attorney's responsibilities: have to act in your best interests, reflect or consider your wishes, and support your decision making. So even if you have lost capacity, it doesn't mean you've lost capacity to make any decision or you have no input. So it's important that if you are an attorney acting for somebody else, that you do listen, and you don't sort of say, well, I'm going to make this decision, but I think it's best for them. If you actually think that they wouldn't actually make that decision themselves. It's important to keep records of the transactions, not mix your finances with their finances. It's always good to set up a separate bank account, but they can be reimbursed for reasonable costs. I'm whizzing through this very quickly because we haven't got a lot of time. Okay, future health planning. You can deal with your wishes, future neck, should you lose capacity through an EPOA, but there are other things that you can also do. There is an advanced care plan, or the advanced care plan is what New South Wales refers to, but we call it here a statement of choices, but it's essentially an advanced care directive, which can be made, and there is a document you can download for that. It's not binding on anybody, but it does carry significant weight. So if somebody has this document and they can see what your wishes, what you want, then especially within a family which might disagree about things, if you have an advanced care plan, then it'd be difficult for family members to say, well, actually, I don't agree with that plan. Do something else. There is a health directive, which is binding. So that's also something you might want to consider, where that's often given to an attorney or family member, or a hospital, or wherever you get your care. If, for example, you're in a hospital and you're unconscious and a decision has to be made whether to pull the plug or not, then you can say under what circumstances they pull the plug, essentially. Okay, I'm going to do a case study here. Terry is thinking about moving in with his son, Ben. Terry is 73 and lives alone. A recent illness left him frail and was able to cope. Ben suggests to Terry to sell and lend money to him and his wife to buy an extension for Terry to live in back in his backyard. Ben will provide his father's family daily care. Well, he said that's what he intends to do. Terry moves in with him, but their relationship breaks down. Ben's sister, Mary, has a son who is disabled, and she lives in public housing. Now, there is an issue there if there's no agreement in place. So there's trust there. Ben and his wife might have the right intentions initially and say, well, great, you sell your home, you can live with us, we'll look after you. It could be some things change. There might be separation, there might be disagreement with husband and wife about how care is taken. There could be issues with how much care Terry can provide. It might be too much for him to do. So a relationship could break down, and the issue is Terry has sold his house on the belief that he's going to be looked after, but he's actually not being looked after. And there could even be elder abuse in that case. So the question is, what can he do? Well, the issue is, had he not moved in, he kept his own house, he might have been able to move into a retirement village, he might be able to get help from the government to stay in his own house. But the issue is, if he's put all his money into the house in relation to Terry and Ben, and Terry dies, and he's left a will, then he's got no assets left to give to Ben's sister, Mary, who actually needs money, particularly because she's a disabled son. So it can be very messy, and so something to think about before we make that decision. So granny flat arrangements, that's essentially what I've been talking about. Build a flat or bungalow, renovate or extend, pay off the mortgage, buy a new house. Sometimes we've had a client who the son had a small house, he had a small house. They both sold and bought a new bigger house, and of course the older person wasn't on the table, so caused issues there with respect to it. So it's an important thing to look for. So export assets for care. Things to consider before you think of such arrangement is, can you get the money back? What happens if things turn sour? Is the money a gift? What happens to the property under a will? Because of course, if property is mixed or given to somebody else, it doesn't form part of the estate. And there's other things, for example, if you've given away money, it can have effect on the pension, tax, and so forth. So there are things you need to take care of. So it's important to have, if you're going to do that, have a family agreement, have a contract or a deed in place to ensure that you're protected. And of course, there's always residential aged care to consider. So I'm sorry, I'm going through these pretty quickly. And as an alternative for an assets repair arrangement. Okay, so you can continue to live in your own home. There are supports available around. I'll just talk briefly about elder abuse. Elder safety, as I like to call it, elder abuse has a connotation where abuse, people think, oh, abuse, but abuse can be very subtle and it can be very mild, but can have a devastating effect. So elder abuse is considered any act which causes harm to another person and is carried out by someone that they know or trust. It can be financial abuse, emotional abuse, social abuse, neglect, physical abuse, sexual abuse. Things that we often see, financial abuse, emotional abuse is more common. Social abuse where there's a restriction, you can't go out and visit your family, friends or something like that. Isolation and that kind of thing can happen. And this often happens where you've got an adult child living at home with the older person. Elder abuse is a crime under the Crimes Act. It's not called elder abuse under the Crimes Act, it's called an offence against a vulnerable person. So it covers a wide variety of people, including older people who are vulnerable. Okay, there are risk factors in relation to elder abuse: dependence on family members for assistance, physical disability, cognitive decline, family conflict, stress in care, isolation. Mature-aged children with health issues, and that can be a problem if you're living with the older person living with an adult child who has their own issues themselves. Living with the perpetrator, poor literacy and poor awareness of rights. Okay, so there's warning signs of elder abuse. The older person seems fearful or worried or withdrawn. Older person seems nervous or anxious when talking about spending time with certain people, family or friends, and denied access. Older person no longer is social or involved in community. There's unexplained injuries, bruises, broken bones, that kind of thing. The older person doesn't have enough money to live. This is not uncommon, where the attorney is using the money for themselves and not providing food and clothing to the older person. Unusual activity on bank accounts and that kind of thing. Sudden or unexpected changes in the will or other documents, disappearance of possessions, absence of necessary health items, and hearing aids. So this is warning signs and that kind of thing for people who you may know, and these things are happening. So it's important that they get assistance. To support somebody experiencing elder abuse, it's important to listen, give reassurance they're not at fault or no one deserves to be abused. Let them know they're not alone and there's help available and for services available. There are other places like Atticus who also advocate for older persons, suggesting support, that kind of thing. Strategies to improve safety and respect and independence and choices. So there are things that can be done when somebody is experiencing elder abuse. However, some of the things we've come across when we do see clients suffering from elder abuse, they're often reluctant to talk about it, and they're often very protective to the abuser because where there are potentially criminal offences occurring, and even if it's not to that level, there are certain legal things you can do when we've suggested that the older person doesn't want the perpetrator to get into trouble because they're a family member, they feel, so it's very difficult to deal with people suffering elder abuse at times. And so it's can be quite a challenge. In addition, it's important that they maintain their relationships as possible and to regain control of their lives, and that's what we endeavour to do. So if there's nothing necessarily legal we do, sometimes I'm offered to write a letter of demand to the child, tell them to stop what they're doing, or there's serious consequences, even that the older person doesn't want that to occur. So it can be a challenge. So safety planning, these are some things you can do to avoid it happening in the first place, or if it is happening. So safety alarm, talking to neighbours, keeping a list of up-to-date phone numbers, having a safe place to retreat, and that's reviewing access to bank accounts, keeping important documents and values locked up, setting up direct debits and send pay, opening a separate bank account, making sure they don't have access to the password and login, identify supportive friends, families, support groups, and so forth, to enable that person to feel safe and get connected again. Okay, I think we're going to have questions at the end. Oh, okay. Does anybody have any questions? Yes.
The next POA, as well as everything in the POA and if it's otherwise.
An enduring power, well, you can have both. So you can have a power of attorney that operates now, and you can have an enduring power of attorney that operates when you leave with capacity. So there's no reason why you can have both.
I always thought that an enduring power would include an ordinary power.
No, it doesn't. No, it doesn't. So there is a separate document. There is a power of attorney document, and there's an enduring power of attorney document. There's two separate documents. Any questions?
You were saying about yeah.
Oh, it's absolutely valid. So if you had a client, someone said, "Oh, I had a bill for 1974," well, it's still valid and enforceable. So unless things have changed, it's still valid. We wouldn't need to change it. Yeah, we would recommend drafting your will and just adding a child rather than you can do what's called codices where there's an attachment to the will. Generally advise not to do that. Because it would mean two separate documents and so it's best with word processing these days. They've already learning off that's already got the original electronic form systematic names. It's quite easy. So the power of attorney, an ordinary power of attorney operates now or could operate in a month's time. You can't specify a date. And it means somebody can act, oh, well, it can kick in now. So if you sign a document today, it can be operated now. So for example, you're going overseas this evening and you think, oh my God, how am I all my bills going to pay and how is somebody going to access my bank account or go to Centrelink to sort out a problem, because you might get a letter from somebody saying you need to do something, but you're away overseas for several months. There might be issues there, so you might want a family member or a friend to take care of that for you. So if there's a power of attorney in place, they can go to Centrelink and say, or go to any organisation and say, look, I've got a power of attorney for this period, or the period of holiday, and I can act essentially on your behalf. So that's useful, or it can be other things. There can be a more limited power of attorneys for specific things. I mean, if, as I mentioned before, if there are older people who are not very internet savvy, but they need to use the MyGov account, so you could specify and give somebody a power of attorney just for that purpose, or logging into my Gov account and uploading documents or dealing with Centrelink, for example. I think Centrelink also have their own power of attorney as well. It's a form. And yeah, and it gives the attorney, you're the principal, you make the power of attorney to give your powers to your attorney to act on your behalf for certain things. So it could be financial, could be other things as well.
That would only be for finance property. You can bank for
No,
personal or medical care.
no, for personal medical care, it's there's an enduring power of attorney. for that. But you can get that operates generally when you lose capacity. But it can also operate during marriage, and it does have a provision in there in the form where you can have financial matters operate now.
But if you did that when you're enduring power of attorney that you commenced immediately, which is only applicable for personal and financial, that would be equivalent to a power of attorney document.
It would be, yes. Yeah, so you could have financial matters operating right now. But the advantage of having a standalone power of attorney is that you can it has the advantage of being for a particular time. So like travelling, you wouldn't want to necessarily put the travelling bit in a during power of attorney. Okay. Yes. Yes, the enduring power of attorney covers everything. So there are separate documents in the same bonus, yes. So but in the ACT, you only need one document and it covers financial, everything, including medical and health. Yeah, so just a matter of ticking the right box and saying. Yes. Well, there are risks. So say, for example, the question was the risks in not providing for people who are dependent on you in your will. So, so a lot of people think of challenging the will. Of course, you can challenge the will simply on the basis that you believe at the time the person drafted the will they had lost capacity, but that's a difficult thing. That's quite rare. But in terms of under the family provision law, you can an interested person who might be a child or might be a dependent, or could be an ex-spouse or ex-de facto, could challenge the will if the provision is not made. But I'll give you a very simple example. You have 3 kids. One of them is Australian and don't talk to them in that way. You told me to do anything for them. And you want to just give all your property to the kids. Well, it opens up the challenge to the third kid. So, but I often say to people, well, look, when you brought kids into this world, did you? Well, I think the argument is that if you did, treat them fairly, why not treat them equally fairly? It's fine. I'll tell you more.
Like you are like normally that you have it's a regular thing to be
Well, it can be, yes. So if you leave your partner everything, on the understanding the partner would have a will to leave it to the kids. Yeah, that can be challenged, yes. Well, it is, yeah. So, and if generally speaking, if you've got grounds to challenge, even if they're a little bit things, but at least there are grounds, then legal costs come out of the estate. So it's important. So you're better off giving the person you don't want, the third child, something.
even if you
Yeah, that's right. So if you do get them, yeah. So that's right. Challenge. So in Australia, we've got kind of a little bit of a mismatch. You can give your will, you can give anybody anything under your will, but if there are dependents that have been dependent on you, then they can challenge.
And temporary standing complaint, just by being, as you said, strange and not undertaken by the authority. And a strange and 30+ years, no relationship between the therapy guide and yet, it costs you the company say.
Yeah, that's right. I know. Yeah, it's possible. So you have to drive the law in terms of boundary provision, or whether you like it or not, and to avoid cost to the estate and maximising the amount of people get without just giving it to all the kids.
So if you have to maybe the lion's share of there are other ways to take the impact of
Well, yes, you can. You can avoid family provision. I mean, if you transfer assets before you die, it doesn't form part of the estate. In New South Wales, it's different. They've got extremely strong anti-avoidance laws, where if you attempt to transfer things, for example, a year before someone's dead, they can actually call it back. They call it national estate, but I don't want to talk about New South Wales. Here, no, yeah, it doesn't matter because it's the place where you reside, to domicile. So even if you've got a New South Wales will, if you live here and you've taken up residence here, then it'll be dealt with under ACT laws. That's right. Yes, but there's also other documents you can do. You can do a trust that, if carefully worded, can operate on death without being a will. You see, if something's totally revocable and it operates on death, it's going to be a will. But you can draft a trust such that it actually operates now, and it gives somebody rights to the money now, even though they don't get it on death. If you do it that way, you can avoid the money becoming part of the trust money, or the assets becoming part of the estate. Yes.
It's agreed together. You're not going to cut that person out?
You could potentially, but you need, you could potentially agree to that, but it could still be challenged. You'd have, I think I think you have to get a court order. I'm not thinking of New South Wales now, but you might have to get court authorised. That court authorised so that person can't challenge under family provision. But simply a simple family agreement though is not going to be sufficient. So there's public policy interest in somebody sort of agreeing not to invade the estate before death, and then so the family provisions they're pretty strong. You can't sort of agree to take away your rights generally. Yeah. Thank you, everyone.
Thanks, Adam. And Adam is going to stick around, and there's a couple of other people from the Legal Aid ACT team, so they're more than happy to answer questions. So next we have Fiona, who is from Services Australia, the Financial Information Service. So please make her welcome for the great work of that when it comes to all of these financial decisions and situations.
Thank you. And I would also like to, so I would like to acknowledge the traditional owners of the land on which we are meeting and pay my respects to elders past and present and emerging, and welcome anyone of Aboriginal and Torres Strait Islander descent. My name is Fiona and I am a Financial Information Service Officer with Services Australia. This is a free, independent and confidential service available to all members of the community. It's to provide education and information to do with Centrelink payments, to do with finances, could be to do with superannuation. And the big things are aged care, and if you're going to be selling your home or planning alternate accommodation arrangements. So I'd like to pick up with a subject that Adam was just talking about moving out of home and moving with the kids. It can be quite complex, and I'll just start with some of the disaster stories I've seen. So we have parents that sell the home, they move in with the kids. I had a situation where the child died. The partner had young children. There was a mortgage on the property. They couldn't service the mortgage. They wanted to sell up and move closer to their family. Parents ended up with nowhere to live because they wanted their grandchildren to have a roof over their head. It started off fine, but there was an unexpected event that meant things didn't work out. The second one was where a child, same situation, but the child actually was in a motor vehicle accident and the house wasn't suitable for them for mobility reasons. They then couldn't find a house big enough to accommodate them all. So again, it became a bit of a disaster. There's also where there are relationship breakdowns with the family members that they've moved in with. And that has become very messy. I did have one situation where it was two sisters that had moved into a property together, and one sister had paid the money for a granny flat interest, so her name was not on the title. Things went all right for a while, but then the sister became a bit strange and they just didn't get on, and the sister didn't want to leave the house. The person couldn't get their money back because the other person didn't want to sell the house. So there are a lot of things to consider, and it's where we recommend you get legal advice and take into account those sort of situations. You can't cover everything, but it's just looking at, in the event you can't stay with your family member anymore, that they provide accommodation for you somewhere and that accommodation is suitable. Now, in Stanley, we do call it a granny flat arrangement. It doesn't necessarily mean the only little granny flat. It could be that you're staying in your own home. But I've also seen where that's been a disaster because they had a granny flat down the back. They transferred the title to the daughter, moved into the granny flat, the daughter moved into the house, and then it was like, well, don't come near me, mum. I don't want to have any contact with the grandkids. Just stay in your little area. That was it. And it's absolutely heartbreaking when you get these people talking to you and then saying, well, you know, I thought I was doing the right thing and it didn't work out. So sometimes it might be having a trial period, living with people to see how it works out, because what your expectations and what their expectations are can be completely different. I've had ones where they've been expected to be living babysitters, and these are very active people and they wanted to travel and they wanted to be out every day and sometimes out all night too. So it wasn't, you know, the family members had different ideas of how things would work. Some other situations that I'd like you to think about are becoming partner, because people are living longer and they may end up in new relationships. It could be the second time or the third time or fourth time around. And if you've got two homes, it's where you're going to live. The implications are you could lose your entitlement or have a severe reduction in your pension payments if you're on family or veteran affairs, because the other person's assets and income come into play. So it doesn't matter whose name the assets or income are in, we're looking at a combined asset and income test. So there's a situation where you may contact the Financial Information Service just to get an idea of what would we assess, what might it look like, what are some considerations or options that you can provide to us. We can't tell you what to do. The choice is always yours, but we will try and give you things to think about. And that might mean you take the information on board, have a think about it, and contact us again just to clarify or you might think of your own scenarios from that discussion. The next life change event that we often deal with is going into care. It can be a permanent care or it could be respite, but it often prompts what happens when people separate. And it's looking at, okay, we've got information recorded against each member of the couple, and that's their bank accounts, their super, their savings, investments. What's going to happen to those if they permanently separate or if it's an illness separation? So, a couple of points to know. If a couple is illness separated, they are still assessed on their combined income and assets, but we pay what's called an illness separated rate, which is the equivalent of the single rate of pension to each of the parties. The other thing to think about is if you're a carer for someone going into care, so it might not be your partner, you need to look at, well, what happens if your payments are cancelled because you're not eligible for that payment anymore? And we can talk through, okay, these are the other payment options and other considerations. Sometimes it's a bit, at that point in time, it's also considering the ownership of the property, because there may be a family member living in the home that's been either long-term care or they might have been through a relationship breakdown and they're living in the home because there's nowhere else. With aged care, it can get very messy in terms of whether we do or don't assess the home. And it might be right, it might be fine if one person goes into care, but when the second person goes into care and you've still got someone living in the home, they may not meet the protected status, so the home might be becoming part of the assets for working out care. So I'm not going to go into too much detail because it does get complex, but I'd like people to think about what are they going to do for financial planning in the event one of the member of the couple goes into care, or both, because there's a twofold situation in that case. Unfortunately, we all die. We don't know when, we don't have those crystal balls, but it's going to happen sometime. And we can't always be prepared, but at least having an idea of what might happen from a selling perspective. So in the first instance, it might be that there is a bereavement payment. It depends on people's circumstances. It's not always payable. So, for instance, I had a lady who was quite shocked. She was living overseas in England. She was getting her pension there. Her husband passed away. She expected a reduction in pension, but was actually cancelled because she actually owned all the assets. So that was what was being assessed for her rate of pension. So when one party dies, we look at who owns each asset, who has the income. The person that is a survivor, their rate is worked out on what they individually own or their share of any joint assets. At 16 weeks, we will send a letter to say, look, this is the information we have for you. This is the information we have for your partner. Can you tell us if anything's changed? So we're actually asking, have any of the assets been transferred? We don't assume that you're going to get the other 50% because there might be funeral costs, legal costs. In the will, it might have said everything's to go to the kids or go to the home for the disabled cats with 2 heads. So we don't know what's in the will, so we don't assume. We just ask you to tell us if things change. You can come in beforehand, but we allow that period of time to adjust and deal with the death of your partner before we will write out and ask things. Estates aren't always finalised within that period of time, so it could be 12 months, and we allow 12 months for an estate to be finalised, and then we'll be saying, well, what's going on? So that's pretty much in a nutshell. I've been very concise because I've seen, most people's arrangements differ from the very next person, so I can't go into everything. But they're the main sort of things I can think of where you have big changes in finances And there is also the possibility of other people taking advantage of you when you're in an emotional state. Adam mentioned about Centrelink or Services Australia, we call it, having its own power of attorney. It's not a power of attorney form. It's called an authority to inquire, or we call people nominees. And it's where they have been given authority to contact us. It can be to make changes. In some situations, it is to receive the payment. It's really good if you're in hospital and you might just be having a minor procedure, but you're in hospital for a period of time and you can't contact us. It means someone else can contact on your behalf. Some of the things I've talked about, like residential care and perhaps the granny flat arrangement, can be quite complex arrangements, and it can be difficult to take all the information in at one time. I always encourage people to get family members to contact us so that they get the same information. And then it might be a case of you have a conversation jointly with us, or it might be they just ring up and say, well, Mum's talked to you or Dad's talked to you about this. Can you talk to me? I've got the nominee access, and we can go in and have that discussion with them as well.
That won't serve alone, they need to.
You don't have to have both. The thing is that often with either a power of attorney or an enduring power of attorney, it might be that it's only when someone is unable to manage their affairs. We then need medical evidence to say they can't manage their affairs. The nominee form doesn't stop someone ringing on their own behalf. It just allows someone else to inquire as well.
So that indicates, that could actually open to controversial. Who's put this under the elderly person knows?
That's great.
And you don't know.
No. I would, like I've been in the organisation nearly 40 years. So I've seen the other side where people have gone into care or they've gone into hospital and then they're not able to contact us, and they haven't had a power of attorney in place. They haven't had a nominee. The nominees are like the family members are ringing up quite distressed because they have no idea what the parent's financial position is. They don't know where all their bank accounts or if they've got shares or super or anything. We can't tell them anything. And they're at a loss of, well, where do they start with this? And they've got a nursing home saying, you've got to get this information. So, like, I'm probably coming from it from that, trying to help the person. But yes, I have also seen one case where I had an interview with a family member and it was about the parent hadn't been able to pay their nursing home costs. And when I looked at the record, I thought, this is a person that's fully supported, so they're only paying the basic daily fee, which is covered by their pension. Why can't they afford their fees? Person was a nominee and was looking after the money, but when I went back a bit further, this person had owned their own home and it had been sold and they'd gone to live with the daughter. We had no details of that on record. We don't know what happened with the sale proceeds, and I started an investigation, but it wasn't my role to follow it up, so I don't know where that went, but that was where alarm bells just went off for me. It was, yeah, if someone's been assessed one way and you're going, hang on, they should be. And I can say when I have people, like I had one this week, parents in care, the power of attorney who is the only child was ringing up, oh, we can't sell the house, that's my inheritance. Well, she hasn't died yet, so it's not your inheritance yet. This is the fees and charges, these are the conditions. If you don't want to pay that, that's fine, but you've got to work out how you do pay the fees. And that's another thing we get is, power of attorney saying, oh, the kids want to sell the house and then they want their share. Again, it's you're acting in the best interest of your parent. And if you can't do that, you're going to need legal advice to see what's the best interest of the parent. Yeah. Yeah. I'll be very brief with this because it can get very involved depending on people's circumstances. Just in general, if there is a partner in the home, they're considered a protected person. So the home is not counted for aged care fees, and it's still not counted for selling because it's an exempt asset for pension purposes. So the rest of the assessment is based on other assets and income to determine if there are other fees apart from the basic daily. Yes. That's a legal question, but some people don't do both. Some people only do one, like they might be able to have the power of attorney, but they don't have the injury, and some people don't know that there's a difference. I'm not a legal person, so that might be with them. Yeah. Someone saying yes, they can be different people, so.
They are being forward and something.
Yeah, so the question about being a self-funded retiree, when you say free fall, like, if they're outside the Centrelink system.
Yeah.
But we often get them inquiring about when they go into care, whether they need to have a full needs assessment or not. Because they invariably will, at some stage, most likely, come into the care system, and some of them can be means not disclosed and just pay the full fees and charges.
So you don't have to be receiving a Centrelink payment to access the financial information service.
No, and you don't have to be receive settling if you need to go into aged care or home care, but you do need to either not have an assessment and say you don't want to have an assessment and pay full fees, or you have an assessment to work out the fees. Now, with the financial information service, the contact is through calling any one of the call centre numbers for Centrelink. Mostly it's the 132300. When you get through, you say financial information service. That will come through to the financial information line. We do a lot of our information by phone. We also have video conference appointments. We do have some face-to-face capacity. In the ACT, we currently have one officer, but from next month, I'm not really sure what's going to be arranged. I will probably be travelling over from Goulburn maybe once a week, and we are looking to recruit, but we haven't found someone just yet. We do have the 2 aged care specialist officers who work out of Woden and Belconnen. They deal with all aspects of people with home care and also going into care, helping you link up with providers, getting into the MyGov, My Aged Care system, and working out the fees and charges as well. Yes. Yes. Yeah. Yes. Yeah. Yeah. So did everyone hear that question? So the question was, if someone chose not to disclose their income or assets for aged care, so going into a nursing home, would they still have access to the annual and lifetime caps? And yes, they would. They would just reach them much sooner. So it might take them 8 months to reach the annual cap, and it might take them 3 years to reach the lifetime. Okay, so with caps, some people may need to pay a means tested fee when they go into care, or if they have home care. That accrues, and there is a cap at which you don't pay any more during a year, and then there's a lifetime one. Now, those caps keeps changing. They're going to change again on the 1st of July, I think. So I didn't bring any figures because I knew most of them were changing on the 1st of July, and I went, they're going to be out of date in 2 weeks. So if you have a look at the My Aged Care website and put in means tested caps, it will bring those up, or you can go to the Department of Health and Ageing website and look for the schedule of fees and charges. Yes. The people that I've spoken to has usually been family members, and it's where they might have private trusts, private companies, they might have investments that are this long, and they go, we don't want to fill out all the paperwork if it's going to mean there.
Paperwork. It's like 30 pages paperwork.
So some people will go, hang on, if the fees are going to be this, and they're going to be paying a lot anyway, and they're going to reach the cap sooner, well, so be it, we don't have to fill out all the paperwork. Because they're paying for it. So it could be they get an assessment, they only pay $20 a day for a means tested fee, whereas they might be getting charged $200 a day. So they're going to get that cap sooner than if they pay the lower fee. The advantage of a cap is that it's not an advantage, it's a limitation. So possibly, I'm not sure exactly why, but some people go into care, they're not there very long. Other people are there for a long time. So it's just saying if you have to pay a means tested fee, it's not going to be forever unless you've only got a very small amount to pay. So if it's a larger amount, then you're going to reach a cap sooner, and then you won't have to pay that either for the rest of that year, or if you reach the lifetime one, you don't have to pay it anymore. You would still have the other fees to pay. Look, and it doesn't apply to everyone. So that's where, if you want to know about, well, what might you have to pay and get an idea, so you can then look at your financial planning, whether it's in your will. So I have had circumstances where people have changed the title ownership of their property. So often homes are jointly owned between a couple. What they've done is they've changed it to tenants in common, and they might have willed half the house to a child that's living in the property. And that might be to get around the house being assessed at some stage in the future for pension or aged care purposes. It's probably sounding complicated because I'm being very general. It may not be complicated for your situation. So what I would say is, either talk to Financial Information Service or aged care specialist officers to get an idea of what it might be like. On our Services Australia website, we do have FIS webinars, and there is actually 3 that deal with aged care, home care and going into care. They are recorded webinars, so you can watch them as many times as you like. That gives you a really good understanding. But then if you want to talk about your situation, you can contact us directly to have that discussion.
Thanks, Fiona. She will be sticking around, so feel free to grab her at the end. Last speaker is Karen Tui. We're fortunate to have her. She's the ACT Human Rights Commissioner, so she's going to talk a little bit about sort of your rights and avenues for support. Yeah.
Okay, I'm conscious I'm standing between you and opportunity, which is always a dangerous position, particularly for a public servant. So I'm going to whip through this pretty quickly and I'll hang around if you've got any questions. I guess lots of people think about a human rights commission as dealing with world peace, the Middle East, the UN, those sorts of things. Fortunately, in the ACT, we're much more pragmatic than that. the government, and I'll just acknowledge the traditional owners on the land as well, and acknowledge the gift from one of our Aboriginal community members of that particular painting to the commission. So in the ACT, the government has decided that the Human Rights Commission is the one-stop shop for complaints in the ACT, complaints or concerns, and also information provision about all the topics you can see up there. So we deal with discrimination, we deal with health services complaints, which is very popular, I have to say, in the ACT. We deal with complaints about services for older people, so that's things like in-home aged care supports, aged care. So we deal with quite a few of those matters. Retirement village complaints, which is kind of theme for me, I have to say. And so I'm going around to retirement villages and doing some little sessions out there. So if you are in a retirement village and want us to pop out, by all means, make contact with us. We're happy to come out and talk to you about what we do. Health workers and unregistered health workers as well. So everybody who's doctors, dentists and nurses, too fast count, and also people like massage therapists, naturopaths, all those sorts of allied health people or alternative health people. So the sort of the intent behind this is that government has decided that because we're a small jurisdiction, they want to put everything in one place so people aren't getting bounced around from place to place. And so we're sort of a one-stop shop for a whole bunch of things. If there's anything on there that you want to ask me about after this, by all means do so. One of the things that we got a couple of years ago was the jurisdiction called the vulnerable persons jurisdiction. Adam referred a little earlier to the fact that there was a vulnerable persons criminal offence. So I have what we call the civil pathway. So I have an informal complaint mechanism where we try and resolve complaints about mistreatment of older people, so people over 60 in the ACT, or any adult with a disability in the ACT. So it's any person who has a disability, might be receiving NDIS services or not receiving NDIS services. And there's concerns about mistreatment, be that exploitation and abuse of those people in the ACT. We can take complaints from anyone, so you don't have to be the older person. You don't have to be the person who's been exploited in some cases, as we've heard some of the case studies that have been talked about. You can be a neighbour, a family member. We get complaints from first responders. We get complaints from health providers out of the hospitals who are raising concerns with us about people coming in from their homes or from aged care or from retirement villages, and they're concerned about how they're being treated at home or how the services are being provided. There are all sorts of matters that we can deal with. So it's a very broad remit, I have to say. And again, government's tried to make it easy for everybody so they've only got one place to go. So we're a complaint mechanism as opposed to Adam and Legal Aid who provide legal advice on matters. So we're slightly different. We work together quite closely. But you can always feel free to contact one of us and we'll try and make sure that you get to the right place if you do want to raise a concern or a complaint. Pretty quickly, like I said, particularly for older people in the ACT, I do age discrimination. We do complaints about aged care, services for older people, health services. That's both individual practitioners, hospitals, general practice, a whole bunch of things. You'll be surprised the range of issues that we get in that space. We get about 800 complaints about health services in the ACT each year. Get about 300 complaints to do with discrimination on various grounds. And at the moment, we're getting about 60 or 70 complaints to do with what, as Adam referred to, elder abuse. But we're trying to make sure that people understand that elder abuse comes in many, many forms. It might be things like isolating somebody, controlling their finances, controlling who they see, cutting off their access to services. That seems to be a bit of a common one. Some of the issues that Fiona and Adam have talked about to do with EPOAs, we deal with those issues as well, where there's been a dispute about whether the EPOA should have been actioned or how it's being dealt with. So it's a pretty complex jurisdiction. If you've personally got any concerns or you've got concerns about family, friends, anybody you come across where you think there is an issue, again, you can always give us a call and just ask for some information and we will make sure that you get to the right place. I told you I can speak very fast. I'm from Sydney. So again, and Adam covered some of this, so I'm not going to go over it again, conscious of afternoon tea right next to me. Um, but it's good to know that it's a very broad jurisdiction, so we just encourage people that if you've got a concern, please don't let it fester, please make contact with us. A couple of the matters that we've dealt with quite recently, for example, are things like retirement village deciding that one of the residents couldn't go to the dining hall anymore. And so his neighbour was really concerned about his well-being because it meant that he wasn't socialising. We've dealt with quite a few matters in that space to do with the relationship between the operator and the tenants, which can be a bit awkward. We've had a couple of matters recently where it's that situation where a sibling or a adult child might decide that mum doesn't need to be taken out anymore, or in fact, in a couple of matters, she doesn't need heating anymore because they cost too much. So again, don't take that thing about being a human rights commission as being about world peace. It's very much about, I have a communication issue with my dentist, or I've got an issue in my retirement village. We've dealt with a couple of those recently, even to do with things like disputes between people in a village not being dealt with properly by the operator. And I think, as Adam said, one of the things that we're very conscious of is that often people are in those circumstances, they don't want to break the relationship, they want it fixed. So they want the behaviour to stop, but they want to maintain the relationship. So the process that we run is very much a conciliation process. So it's about how do we bring people together, not ignore the behaviour, but try and make sure that the behaviour ceases and that ongoing relationship is maintained. Sometimes people find that a bit scary to get a government agency involved in their personal life. I understand that. On the other hand, what it reflects, I guess, is particularly in the ACT, the government's interest in ensuring that older people and vulnerable people in our community are safe and they've got options. So we work a little bit with the police. Adam mentioned again the offences before, but often that's about the police referring matters to us to say the family don't want the police involved, even though there's some money that's gone missing or there's a question about some assets. What they want is the issue to be resolved, but the relationship to be maintained, because that's really important for people. That's a tricky space, which is why we have people with very particular expertise. But again, our process is very much about focused on how do we try and resolve this, not how do we try and blame people or point out people's faults or problems or where they breach the law, that sort of stuff. Very quickly, like I said, it's a very informal process. So if you ever want to give us a call, please do so. Drop us an email, you can pop in. Our information line is very much about just talking people through their options. It's not about if you call us, you have to make a complaint. That certainly isn't the process. Sometimes when we're getting a call from a family member or a neighbour or even the first responder, like a paramedic, it's about here's some options, here's some language you can use to talk to the person about why they might want to give us a call. And it's very much about, firstly, how quickly can we get onto it? And there are certainly matters that we'll get onto on the same day because they're quite critical. So, for example, if I get a call from someone in the ED, in the emergency department, and there's an issue with their treatment, they're the sorts of matters that we'll get onto straight away. Obviously, some matters like retirement village contracts or some of these aged care matters take a bit longer. But sometimes if we have to go out and interview someone to just get some further information, that will happen within a couple of days generally. Oh, look, that's how quick. Yeah, so really, as I said, it's you guys are also sources of information, both from your community, your friends, your families. If there's anything you think where we might be able to help or you're not sure that we can help, but if you think you want to grab some information, by all means, give us a call. Thank you.
Thanks, Karen, and thank you to all of our speakers for coming today. For those who are regulars to these sessions, next month we've got a session all about end-of-life choices, where we have the team from ACT Health talking about the advanced care planning process, as well as palliative care ACT. So we'll be sending some information about that shortly. And as mentioned, we have some afternoon tea, so please take the opportunity to grab something to eat and get some one-on-one time with the speakers. But thank you all for coming.